Hello, everyone. Welcome to Startups and the Law, presented by JonesKertz. We have Kyle Kurtz here today, who is going to tell you everything you need to know about startups and the law. And he hosts this event once a month, so don't be a stranger and keep coming back. And these videos will live on this YouTube channel. So if you want to come back, send them to a friend. This is where you find them. So with that, I'll bring up Kyle.
Good morning, everyone. Thanks, Alex, for the introduction. And welcome to Startups in the Law, presented by JonesKertz. We are a Dallas-based law firm that caters exclusively to startups, entrepreneurs, investors, and members of the startup community. About 11 months ago, I started this webinar and with the intent in mind that this would be an educational webinar. When we do this every month, we're looking to provide information that a lawyer knows, in layman's terms, so that you can understand when you need a document, when you need a contract, what you need as far as business structuring, what you need as far as hiring employees, all the things that go into running a business. And, we do this with the intent in mind that we want you to be a more successful business. I believe that data is the most important thing about running a business. Yes, you can fail faster, as some people say, but I'd rather succeed more than fail in some cases. And knowing how to do things and when is pretty critical. So as far as the purpose of this webinar goes, we're going to try to give you not just some general info about what to know about certain contracts or what to know about the law, but stuff in general, stuff that is a little more granular as far as, hey, these are deal terms you should look out for. These are things you should think about when you're agreeing to certain things. You don't ever want to just sign a contract without reading it first. You don't ever want to sign a contract sometimes without negotiating it first and making sure you get a little something out of it. So without further ado, I'll introduce myself as well as my business partner, Matt Jones. So Matt Jones, unfortunately, is not here today, though I will drag him into the webinar at some point, maybe when we're both in the same room at some point again. Matt Jones is actually based in Oklahoma City. That's where our other office is. We have one office in Dallas and one office in OKC. So we are a multi-state law firm. We serve all of Oklahoma, we serve all of Texas, and we serve a lot of companies that, aren't in Oklahoma or Texas, or companies that, start in Oklahoma or Texas and move to the West Coast or the East Coast. So you might notice that Matt Jones's email says vergelaw.com at the end of it. The reason for the difference in name, we have to go by two separate law firm names. When our law firm was originally started, Verge Law Group was the name, and it still is in Oklahoma and elsewhere. But unfortunately, about 3 states, including Texas, do not allow us to use what's known as a corporate law firm name or a trade name for a law firm. And so we have to go by our last names in the state of Texas. Though I'll tell you, as far as the logo goes, I'm not mad about it because I think the logo we have is actually kind of cool. But as far as communication, these are our direct lines. So email, phone, if you want to write it down. My email is kyle@joneskertz.com, JonesKertz.com. And, if you have a question that you think isn't covered by this webinar, but probably should be, or if you have a question that you want to ask, either feel free to drop it in the comments section right here on the link, or do me a favor, email me directly at kyle@joneskertz.com. People who know me know that I try to be pretty responsive when it comes to these things. And I usually try to give you as much information as I can without creating an attorney-client relationship, unless you are willing to actually, sign an engagement letter and stuff. But this isn't really for promotional purposes. I'm not always going to be pitching or selling on this thing. As a matter of fact, that's not the purpose of this webinar. This is actually the purpose. So I've always said better education leads to a better foundation, which leads to more successful startups. Like I said, we don't want you failing as a business, and we certainly want to prevent any failures if we can avoid them by just giving you some general counsel, some advice on how to go about certain things. You can't possibly know everything, so lean on the people in your circles, lean on the people in your community, and lean on the people at Capital Factory and other accelerators that you may be a part of if that's where you are right now, because those people will be able to help guide you. I do know that a lot of people, they say a lot of different things about what to know about the certain things, and probably the worst one is venture capital deals. A lot of people are big in advice, and there's not really a whole lot of action, and a lot of the advice is duplicative. The advice that we give, or not necessarily advice, but the information that we give on this webinar is designed for you to understand where you stand as far as certain legal activity that you'll need, that you'll be covering when you are growing and scaling your business. So we're going to go over the topics here. So I'm actually going to go over Robinhood and what happened last week. And I was actually joking with Alex, if you're not talking about Robinhood, what are you doing at this point? So we got to talk about it. And actually, I'm going to weigh in on some of the legal stuff, because I think there's a lot of people thinking and saying certain things that I think are, misguided, and in some cases just not even remotely well researched when the information is directly available to us about it. So I'm going to go over that for a little bit, but I'm not going to take too long on it. One thing I do want to do here, this is kind of boring, but we're going to go over how to calculate Delaware franchise taxes. If you have a Delaware corporation, you should definitely stay on until we're done with this, because especially if this is your first year, or you just finished your first full year of having a Delaware corporation or started one in 2020, you probably got a letter that says you might owe thousands of dollars in Delaware franchise taxes. I'm about to tell you why that's probably not true. And then last but not least, we are going to go over a little more in-depth review of some mobile app and website development agreement terms. And I'm going over that because, that is one of the more frequent documents that that people ask for from us. And, I've seen quite a lot of the documents that come from developers themselves. And, I was talking with my business partner the other day. I was like, what's the deal with these? And why are a lot of developers not using lawyers to draft these initially? And why are people just accepting them despite the fact that they're so flawed and so bad usually? I'm going to go over some of this stuff and, basically explain the why and the what behind the mobile app and website development agreements, and why you should be a lot more critical of them. Okay. So if you have any questions about any of that, or want me to cover some other topic that might not be related, please do drop it in the comments. I'm going to be monitoring the comments actively. That's one of the things I'm changing about this webinar, so that we are actually, answering questions as they come through the chat. So without further ado, we're going to move on. Just one quick moment, legal disclaimer. Like I said, this is not advice. Do not take this as advice for you. Take it as this is just some general information. I'm giving you some general information. You could find this information elsewhere. There's probably blog articles written on it. But I'm giving you a lawyer's perspective on what we look at as far as deal terms go, negotiating points, what we look at as far as legal perspective and analysis goes. And, we think a lot differently than a lot of other people. That's not to say our way of doing things is inherently better than the way people in other forms of business do things. I do think I learned quite a lot from our business clients as far as, this is an acceptable form of this agreement, and we should pare it down, change this, change that, et cetera. But yeah, like I said, I usually say the following though when I'm talking to my clients. I say this almost every day. There are no absolutes when we're practicing law. We are definitely not making absolute judgments on certain things. Everything is qualified with, this will probably be the case. This would probably uphold in court. This would probably not be enforceable. We say the word probably a lot because until you're in front of a judge, until you're in front of a jury, or until somebody arbitrates an issue and officially decides it from a legal perspective, we can't tell you something definitive. So, but that said, we can get pretty dang close most of the time, I'll tell you. And last but not least, if you're not a lawyer, you're not a lawyer. pretty much every day I have to deal with a non-lawyer drafted agreement. I would highly advise, even if you do try to attempt to draft an agreement yourself, pay a lawyer to have somebody look it over. I can tell you, I've reviewed my fair share of non-lawyer drafted stuff. And it's not that you can't do well, because I have seen really good stuff come from people who were not lawyers and have been pleasantly surprised. But I'll say more often than not, there's usually some fatal flaws in those types of agreements. So just learn what your strengths are and outsource the rest is what I would recommend. So Robinhood is, probably the most controversial company at the moment. People keep calling them a startup. Maybe I'm not sure if you could technically consider Robinhood a startup anymore, because a startup is more of a company that's like looking for a business model at the moment. They're sort of still hacking it. And, maybe Robinhood still is a little bit. It seems their PR team is still hacking it a little bit. But as far as it goes, Robinhood is a multi-billion-dollar technology company at the moment. And as a matter of fact, they're slated to IPO soon. And so there's a reason why the millions of users are upset with some of the stuff they did over the last week, and rightfully so, in my opinion. So over the last week, if you haven't heard or you've been living under a rock, they halted trading on about 50 stocks, major names: GameStop, AMC, Sundial. Those are really the top three that I could think of. Sundial in particular, because I actually owned a long position in Sundial and had to sell it as a result of them halting trading on it, so that I could just avoid getting crushed if that was going to happen. When people ask about whether the trading halt was legal, I would say yes, definitely it was legal. And if you actually look at Robinhood's terms and conditions, it is pretty clear that Robinhood, it spells it out and says we can suspend or halt trading on your account for any reason or no reason at all. That's really all they need. They do have the unilateral authority to do that. They don't need anybody else's permission. So I will get to in a little bit why I think they should need somebody else's permission. And you might have seen that there are a lot of law firms putting class action lawsuits out there. I actually had a conversation last week. On Thursday with a friend of mine who had a sizable position in GameStop. And he was actually, apparently, if you have more than $25,000 in assets under management in a Robinhood account, you can have a day trading account. The truth is, what ended up happening with him, he had a sell order that was placed the night before, and about 3 minutes before the market opened, even the early trading hours, he was set to make $30,000 worth of profit. And then they sent him an email saying that all GameStop trading had been halted and that his account had been completely locked, meaning he could not trade at all. And I know that probably happened for a lot of other people. I thought that was, from a business perspective, Robinhood may have the right to do that sort of thing, but you really are inflicting a lot of damage when you suspend somebody's trading account for a reason that had nothing to do with for a reason that really had nothing to do with that person committing illegal activity or anything like that. We have a question: doesn't Robinhood have to comply with SEC rules and regulations around trading? Absolutely, they always do. As a matter of fact, if you look at their disclosures online, they probably have the most disclosures of any fintech company I've ever really seen. And so it's clear to me that they emphasize compliance there. But to give you an idea, and I'll talk about this here in a little bit, a lot of people were accusing them of market manipulation. There could be a legal argument there that, hey, yeah, they did potentially manipulate the market. But, there has to be what's called, the legal term for it is called scienter, which is basically you have to have almost like motive or a reason to do that, right? That, isn't otherwise legal. And so they did suspend trade, let me see, because of a cash crunch to float 3-day settlement. So if you're looking at their explanation, and I'll get to this in a minute. So hold on, let me move to the next page. So as far as this question goes, did Robinhood suspend trades because they had a cash crunch to float 3-day settlement? So with major fintech companies and brokerages, they do have compliance requirements. That volatility explanation, by the way, that Vlad Tenev gave the other day is a real explanation. Yes, they did have a bit. They did have an issue as far as the deposits that they had to make with clearinghouses. And so they would have agreements with a lot of major clearinghouses to facilitate the brokerage of these securities and the buy and sell orders. But I'm going to get to it in a minute why, yes, they had those requirements, but when they ended up shutting down the trades themselves, what they really did, in my opinion, and, this is less of a legal argument and more of a, did they make the right decision argument? They chose winners and losers, because the problem is the hedge funds, the high frequency trading companies, all the other people who had access to the market or were market makers themselves were still out there trading. And, they didn't just stop. It wasn't the entire market that shut it down, and it wasn't the SEC that ordered them to halt the trades. They did so themselves. And, maybe the rest of the industry did too. But, I think it was more a matter of, hey, Robinhood did this, we're doing this, or it was just somebody following somebody else's lead. There was no clear leadership from an SEC compliance standpoint. There was no order that came down that we are aware of that came down from regulators saying, halt the stock, you're done. You're done for now until we figure out what's going on. They did have an issue as far as clearinghouse deposits, but they have massive multi-billion-dollar lines of credit. And so when Vlad Tenev gave his explanation, he said, we did that preemptively so that we would be able to comfortably handle the volatility in the float. Well, okay, then what happened? Why did you have to halt the stock? The explanation to me, no matter how they couch this, will always be a bad explanation, because they ended up harming several thousand, if not hundreds of thousands, if not millions of people in the process. As a matter of fact, I read that approximately half of all Robinhood users owned GameStop when they halted trading, which I think is a ridiculous level of ownership for that stock. Yes, it might have been pumped, but what the people who were following Wall Street bets over a cliff to do, which was investing in extremely risky stocks that were more likely to go bankrupt before they started doing that. It wasn't illegal. It might have been somewhat manipulative, but from a legality standpoint, there was nothing illegal about what was done there. And as a matter of fact, if you look at what hedge funds do, and I know everyone has said this at this point, if you look at what hedge funds do, and the people who run hedge funds, they go online, or they publish research reports, or they do certain things on CNBC and basically give their opinion on investment and say, we're short selling this, or they give that interview and then they immediately turn around and short sell or buy the stock. Well, they have influence over the market. That in itself really is manipulative. So as far as it goes, though, I think there is some controversy here with the way Robinhood makes money. And actually, I want to talk about that right now. So payment for order flow is really apparently the bulk of where, or a large minority, about 40% of where Robinhood makes its money. And as a matter of fact, many of the other people in the industry, including public up until recently, use this system to make revenue. Payment for order flow, like I say here, brokerages are paid to route orders to market makers for trade execution. So basically, they have a contract outstanding with these people who run high frequency trading companies and people who are basically the middleman for all these trades. And they end up, those people are paying basically a premium for access to those trades. And what they're really doing is, they see the order coming through, and then what they do is they buy the stock at a lower price than the order, or buy it at that rate, and then they resell it back to the person who placed the order at a higher price. So if you're actually looking at your trades, if you've ever placed a market buy trade on Robinhood or on E-Trade or on anywhere else, that's usually what's happening behind the scenes. It's usually these people are making riskless profit basically because they can see the trade coming through. And as a matter of fact, there's some stats out there. Depending on what you read, the stats change, but I've heard anywhere from 70 to 80% of the entire market volume on U.S. stock exchanges is actually high frequency trading market volume. We have a comment here. Users can't dictate platforms' actions unless they're paying the platform, which creates a fiduciary relationship. Maybe can't dictate platforms' actions unless they're paid. I don't know about that. I get what you're saying as far as users can't dictate platforms' actions unless they're paying the platform, but it's as a matter of fact, the users. I mean, it's the will of the people, and the users. If they decide to all leave and take their money, they have influence. So, that's not necessarily legal argument. It's more a matter of just they can definitely dictate the actions of privately held companies that are massive if they choose to cause an uproar and do that. So I do get what you're saying. Yeah, I do feel sorry for the people that did get blown up on Robinhood, or at least move the market substantially. In some cases, it's just. Like I said, I don't think what Robinhood technically did was illegal. I think they were allowed to do it. I just think they shouldn't have, or they should have gone about it in a better way, or at least I'll get to this, but I do believe that the SEC should have actually stepped in and said, halt the stocks on all of these. And it should have been a regulatory decision. I'll get to why on that in a minute. But yeah, as far as you've probably heard of companies like Citadel. Citadel was was apparently 40% of the revenue for Robinhood, and as far as that goes, like that really was a conflict of interest. A lot of people saw that there were transactions happening between Citadel and that hedge fund Melvin Capital that ended up going under. So it looked like there was a little bit of double dealing. And it looked like Citadel was maybe using the inside knowledge and information that they had to potentially make some sort of ill-gotten gain off of it. That's what most people are arguing. I don't know if that was actually the intention, but the optics were definitely not good. Robinhood users definitely their trading activity is definitely the product there. I'll tell you, that's really what is being sold and bought. When something is free, when something is totally free, you have to envision okay, how are they making their money? A high growth early stage startup can run a loss for a little while, but they have to do something to make cash. And maybe when Robinhood first came out with this sort of thing, or maybe when high frequency trading first became a real thing, that's when this payment for order flow thing was really born. From a digital standpoint, because before then it might have been a lot less sophisticated and automated. There's a lot of financial engineering and algorithmic trading that goes on behind the scenes. You might have heard of quantitative trading. In those cases, I mean, you have people with advanced degrees, basically PhDs, programming computer code to detect when a trade would make profit for them, and it would instantaneously buy and sell. If you've ever read the book Flash Boys or ever interested in learning more about high frequency trading, I would definitely do that. I do want to say, maybe I wasn't clear enough about this. I disagree with the notion that the users themselves are the product. It's really their trading activity. That's splitting hairs, but whatever. This is what I was talking about before. So Public has decided that you can tip them instead of that you can tip them now, and that they will no longer do payment for order flow, because they said from a business standpoint, there was no one in the market that was truly leading anymore, or had been leading as far as fintech brokerages go. like Robinhood, like Public. And so nowadays they're actually, if you make a trade, you can tip them. But just so you're aware, we've done several fintech transactions, helped set up fintech companies. Those agreements are by and large some of the most expensive agreements from a service agreement standpoint, I will tell you, that I have ever seen. And if it, like, at some point these companies do have to make money, and I believe that this decision by Public will potentially crater their business, because you're basically saying we're going to get rid of a large minority or majority of our revenue willfully. And I do not think the people trading on Public will end up paying them as much in tips as they think they're as they hope to get. I don't think it's going to cover their costs whatsoever. I can't imagine it would. But I also have a graph here explaining, sort of very simply, this is from Bloomberg, by the way, how payment for order flow works. And so what this is leaving out, though, is it claims is required to find the best execution. The best execution is the one that makes the middleman the profit in that situation, just so y'all are aware. The best execution is the one that makes the high frequency trading companies the most profit. And like I said, in itself, that's probably a conflict of interest. You're giving people, you're basically providing all the power to a subset of people or entities that, if they decided to shut the faucet off, could cause a lot of harm. But yeah, I said probably not. They didn't do anything illegal. In some ways they had to save themselves. I read that initially, apparently the national regulator run clearinghouse that they have an account with initially wanted to charge them $3 billion in new deposits for the volatility. Apparently they got that capital call notice at like 3 a.m. on Thursday morning, and they apparently negotiated it down to something like 700 million. But I get that they may have had intense capital requirements. Obviously, they don't have infinite money. That might explain why they had to raise $1 billion. I'll tell you though, somebody asked a question on Twitter last night that I read, and it was like, who knows any VCs that could give you $1 billion in 24 hours? Most likely they didn't. They got it from existing investors, but a lot of those people are probably going to be the mega huge VC firms, or they're going to be private equity firms themselves. So the private equity firms themselves will have $1 billion in liquid cash on hand, or they will have agreements with the investors in those private equity firms to basically issue an instantaneous capital call notice and basically draw down on the account for investment. So that explains why they were able to get $1 billion in cash. I don't think they were that's probably just to be comfortable. It's not like Vlad Tenev just gave away the farm as far as ownership goes in his business. I can't imagine the dilution. The dilution was really all that significant for a company like Robinhood, even though they did take $1 billion in. So here's a comment. Somebody in the federal government should have a conversation with the folks at Reddit, where a lot of this volatility and churn started in the first place. The people on Reddit, yeah, I would say some of that stuff, it went from, hey, we're trying to run like a Reddit forum, an online forum that provides, a community for investment and, like advice. But it's now become pretty hostile and openly hostile, to the point where, the thing they did with Melvin Capital, destroying a company like that, in my opinion, Melvin Capital should not have been that exposed. There are very simple ways in which they could have protected themselves from runs on their shorts, but they definitely did not do that, in my opinion. And most hedge funds are probably looking at their shorts and saying, okay, we need a level of insurance in the form of calls on stock that we're also shorting, so that we're not absolutely losing our ass on that stuff. But yeah, my proposed solution to this, by the way, is, a regulator like the SEC should have delegated authority to provide consent to brokerages and other market makers to halt orders on this stuff. And in my opinion, really, like if it's going to be a decision to where you can sell the orders but you can't buy them, that needs to be imposed on every trader and not just on one individual market. Because otherwise what you're doing is you're creating a system where the hedge funds at that point, who do control billions and billions and actually probably trillions in dollars in US capital, are going to sit there and use that opportunity to drive the price down intentionally with shorts. If you can't buy anything on the open market. And so they will, the retail investors really are at the will of those institutional firms in that situation. And I think that's something that could be regulated around. As far as it goes, though, I think at this point, as far as the deposit increases, I think what should really be looked into is, why was the initial deposit request $2.3 billion more than what was agreed upon between Robinhood and the NSCC? Because I was just reading it going, why would it be that much more? And you could not end up, and they ended up just having to negotiate it. In my opinion, those things should be set. I mean, there should be metrics that are used that, here's tiers in which you have to, like, here's how much you'll have to give us if this happens, how much you'll have to give us if this happens. There has to be some sort of quantification of all of that stuff. So aside from that, I'm going to stop talking about it because it is a bit incendiary. People do get people do feel very intense about it. I personally do think that Robinhood made the wrong call, but at the same time, everything's 20/20 hindsight. When they made the decision, they're dealing with information that is available to them, and the general public does not have all that information. So if what they did was truly right in their opinion, I mean, I think they'll have to do maybe publish a book on it and why it was right, or publish a white paper and why it was right, or allow us the information so that we can judge for ourselves. But yeah. Anyways, franchise tax filing dates and info. So I've gone through this in the past. I'm going to go through this really quickly, except with respect to the franchise tax calculation for Delaware, because this has been a big issue. I had a conversation yesterday with Matt Jones. All right. And Matt Jones, in the first 3 months of every year, we get phone calls from our clients, and our clients are sitting there going, what the heck? This company you started for me back in the last year just got a notice that we owe $77,000 to the Delaware Secretary of State. And every single time I have to tell them, no, you don't owe $77,000. As a matter of fact, if you did, that would be really bad for me, because that would mean I had done something really, really wrong. But that said, like, for the most part, most people just don't understand that information that's coming to them from the Delaware Secretary of State. So I am going to explain it here. But before we do that, here's the deal. Texas franchise tax is going to be due May 15th, as it always is. You have tax due if your business made more than 1.18 million per year, or if your business falls into a category that is taxed from a sales or use tax standpoint in the state of Texas. Is the tax threshold for 2021 is the same as it was last year, 1.18 million. It goes up every now and then based on, I believe, based on the inflation rate or something like that, or based on some sort of predetermined rate of the state. Doesn't really matter, because we tell people about it, about the new rate every single year. Delaware filing deadlines, LLCs, June 1st. If you have a Delaware LLC, make sure you put this into your calendar, or at least get it on the calendar for you to do. Corporations do March 1st. So even before, your normal personal taxes are going to be due, you have a deadline on March 1st for a Delaware corporation. And a lot of tech companies have Delaware corporations. So we definitely have to, this is definitely something we're dealing with in the last month in the lead up to March 1. So how to calculate Delaware franchise taxes. So there are two methods of calculating Delaware franchise taxes. And really the determining factor here is on your certificate of incorporation, the first document that was ever created for your Delaware corporation, the one that your lawyer probably drafted or that you got Clerky to fill out an automated form or something that you went and got LegalZoom to do for you, there's usually going to be par value that's listed on it. And usually it's going to be something like $0.00001. And, from a franchise tax perspective, we want to make sure that when we're filing certificates of incorporation, that it includes a par value on the stock. Because if it doesn't include the par value, then you have to calculate your shares based on the authorized shares method, which, by the way, is going to be really expensive. More often than not, you will use the assumed par value capital method to calculate your shares, and typically your shares are going to be, the franchise tax is going to be nominal. It's probably going to be $400 or $175 or something, or it's going to be like $400 or $1,000 or something like that. As far as calculating it goes, there are resources online. Delaware has its own franchise tax calculator. They have an Excel spreadsheet for it, which I think is amazing, because rarely do we ever get anything that's provided by a Secretary of State. I mean, as a lawyer, as far as public resources go, I think most states do a very terrible job of doing anything past helping people get an LLC going. And even then they do a pretty poor job of that to begin with, because it's usually a very unapproachable experience. You usually need somebody who's done it before to help you with it, or you need to call somebody like us or an accountant to do it for you. But yeah, you can Google Delaware franchise tax calculator and you can pull it up. I believe the most recent version that you'd look for is the 2018 version. And that's on the Secretary of State's website. So don't pay anyone to do that if you think you could do it yourself. That said, if you can't do it yourself, I recommend having your accountant, who, when they're going to file your business taxes, if you have an accountant, have them do it. Okay. This is just a screenshot from the website, which shows this. I'm not going to go through all of this because this is, in my opinion, very, very, is very, very, poorly written and unreadable pretty much as far as it goes. But just so you're aware, it has information that just sort of tells you in layman's terms what the general process for calculating franchise tax is under both methods that we just discussed. But I'm only including this one. I'm not including the authorized shares method because almost nobody uses the authorized shares method. The assumed par value capital method is the one you're looking at. Here is literally a screenshot from one that I did this morning for a client. Okay. So, when we create a Delaware corporation, we usually authorize 10 million shares on the certificate of incorporation. The reason we do that is, it's almost like an industry standard. Yeah, it is a bit arbitrary, but 10 million is a good round number, and it provides us with a little bit of wiggle room. I've seen people do 1 million shares. I've seen people do 5 million. I did one that was like 142 million shares the other day because the client wanted a certain amount outstanding and issued just immediately. And that company was a fintech company that we plan to take public in the next 2 years. And so we had to do something early on to make sure that the calculation itself would, so that we could provide for a situation like a stock split without it looking too severe to the shareholders. But yeah, so for this assumes one class of shares, by the way. So if every share is basically going to be the same, every share is just going to be a share of common stock that gets the same amount of votes, then this is what we're looking at. Typically we're looking at a 4 to 6 million share range as far as the total division of issued shares initially for a Delaware corporation. We've done 7 million shares, 8.5. I mean, we don't really do We don't really do 10 million shares issued immediately because we want to make sure that we give the clients a little bit of buffer to go raise money, to give some out to service providers and incentivize people with the equity of their company in addition to cash payment. But yeah, you look at this assumes that, hey, maybe you've taken $100,000 in investment, right? Before the end of the year. So you got 100K in the bank. You got 6 million in shares issued. And then we got 10 million authorized at the par value I just said. And, it basically provides you with that assumed par value calculation. And then we get our total tax of $400. And that's the calculation you will use. So please, if you ever start a Delaware corporation or if you just started one, take a deep breath, read your certificate of incorporation, check for that par value, and just remember that you probably do not owe upwards of tens of thousands, if not hundreds of thousands of dollars in taxes. I did have the client that I was just referring to that we started a business that had close to 150 million shares outstanding. They got a notification that they owed 419 grand in taxes, or something ridiculous. It was either that or it was $441,900 in taxes. I can't even remember. But the moment I saw it, I knew exactly what was going on, and I told the client to just stop freaking out. We already did the calculation when we set the company up, so we're good. And I just sent him a revised calculator because we had raised money and there was a different gross assets calculation than what we had assumed before. And at that point, we just ended up filing the Delaware franchise tax and called it a day. So if you have any questions about this, like I said, ask your accountant. Someone like us could do it for you as well, so long as you have the information at hand. Okay. But just don't freak out. So Texas is a little bit different, I'll tell you. You have to go through and file on Texas's controller website, like a public information report. And I believe the systems are slightly different, and so it's not going to be the same. To me, this is really particular to Delaware. To be honest with you, we've never had this issue come up with a Texas corporation, surprisingly. So that tells me that the way Delaware does this is not just strange, it's probably against the grain of the general, business industry as far as starting businesses go. As a matter of fact, there's thousands of articles probably written on it where people are criticizing the Delaware Secretary of State of basically giving people heart attacks unnecessarily when they could easily solve this problem by sending them the assumed par value calculation automatically, or just sending them an email saying, please use this to calculate your franchise tax. Texas doesn't have this problem though. I would have to check back in to see exactly what the calculation truly is, because I've never had to do it, to be honest with you. But it is. If you do have to pay certain franchise tax fees, it's extremely nominal, I'll tell you. But does anyone have any other questions about that? I sort of blew through that. We are 45 minutes in, and so that will provide us with the bulk of what we're going to talk about for the rest of today. By the way, if you have a question about that Texas franchise tax / par value thing, feel free to just email me and I'll go ahead and see if I can find you an answer to that question. Okay. As far as mobile app and website development agreements go, these are some of the most common agreements that we do as tech startup lawyers. So, shortly after we set up a company, usually they're either self-funding development for software or mobile app or a website. I would say more often it's going to be a mobile app or, proprietary software if they're not creating it themselves. And so we're looking at, sometimes we end up hiring people on and we'll give them equity in those companies, and they'll go in, and those people we hire will go in and do the programming. So we don't necessarily need a software development or a mobile app development agreement in those situations. This is more in the context of, let's say your company does need development. Your company does need development work, and you're looking to outsource it to a third party or a third party company, and you're not looking to make that person a direct employee of yours. You're not looking to put that person under your umbrella of control. You're looking for that person to just be an independent contractor and just do some work for you for a limited period of time. More on that. And, I think the emphasis here is going to be a lot more on mobile app versus website development agreements, because, I think it's a lot, as far as a website goes, a basic website is not difficult for anyone who builds websites. If you are integrating, though, a mobile app with a website, if you are doing anything trickier with a website, then it does take some, you do want to make sure that we're getting these agreements right up front. So without further ado, I put together this comparison, and when I was done with it, I realized that, it was probably unnecessary, but I think it's demonstrative of how similar these agreements are. So I could have just made this a normal slide instead of making it a comparison slide. But the major difference here is that, I've discussed it with Matt Jones a bunch too, about like why these agreements are never done together usually. And, a lot of people are looking for somebody to do a mobile app, and they're looking to get the mobile app developed. And I'll tell you, a lot of times they actually aren't trying to integrate it with a website. We talked about Robinhood a lot. When Robinhood first came out, you probably noticed that, maybe they were developing the back end of the website itself while they were developing the mobile app. But to me, a lot of people are now focusing on, hey, we want the mobile app to be the system that is used by our clients, because they're trying to narrow down the product offering and move people online via their phones. If that's the way they want their customer experience to be run, is, we want the customer experience to be 99% mobile app and 1% website, then maybe a lot of people are holding off on programming integration for a website in that situation. And it is a different skill. It does require different, different types of programmers in some situations to do. Though I will tell you, the other day, I actually did create probably, for the first time in a while for our law firm, a dual website plus mobile app development agreement. And the reason we did that is because integration with the website was key to the development. And they wanted to make sure that they had, if the website isn't going to go live as far as integration goes, they still wanted to develop that resource so that when they do get more funding, when they do get more users, they can actually experiment with, hey, let's beta test the website. Let's see if people will use it online, that sort of thing. So, but yeah, you can tell here that these are extremely similar. And so when I'm talking about these going through these slides, just keep in mind that if I'm saying one thing for a mobile app, if I'm not pointing it out directly that this would be different for a website, then I'm usually going to treat those as like what I'm saying as generally the same, because the terms are literally usually a mirror image of each other. So as far as, most important terms go, everybody talks about payment first. Really, it is the first line item. Usually though, the discussion goes, this is what I need. And then somebody says, okay, let me think about what it's going to take to build this, how many people I might need, licenses for APIs and other code that we would have to buy, open source components, et cetera. And, as far as it goes, like the fee, these are the fees that this programmer will earn. There are market rates for programming. A lot of you people can probably school me on all of that. I'll tell you, I generally hear, $100 an hour is where people tend to see the mean or the average rate. I've seen it be more. I've seen it be 120, 125. But as far as this goes, when we're looking at payments, we do need to get how much down. And then, what increment? So is this a milestone based contract, or are we looking at, if this is just, hey, for whatever programming you need done for the life of this contract, we'll do it, but it's going to be hourly and we're going to log our time. And then we're going to tell you on a bi-weekly or a monthly basis, this is how much work we did. Here's the invoice. The only thing I would caution you about, like, I was reviewing one of these agreements when I was creating these slides, and I do want you to know that if you agree to a royalty fee, just know that that is, like, I would not recommend it as a lawyer, because from an ongoing compliance standpoint, it requires that you number one, you have to do accounting for that. Number two, you have to basically give audit rights for that sort of thing to anybody who's being granted a royalty. And, maybe you would grant a royalty in a situation where you don't have the funding to be able to pay these people full rate. But at the same time, I would tell people, you're giving away a portion of the income of the business. And most people will negotiate the royalty fee to be a revenue-based royalty fee instead of a profit-based royalty fee. In which case, you're taking a haircut off the immediate top of all of your off of all of the business you might earn off of the app that you're creating or the website that you're creating. And so I would definitely caution you against it if that is something you had considered. In lieu of a royalty fee or in lieu of other payment, a lot of people might suggest to their developer, how about we give you X% of the business? I also want to caution you on that as well. So it's a lot easier to walk away from a service provider you don't like if that person doesn't own a portion of your business, right? Having that person just be a vendor for you makes the relationship much less emotional. It definitely provides a little more, you're going to be probably in the long term a lot more cordial and a lot more professional with that person. And you're never going to sit there and hold it over their head, right? Well, I could just pull this contract and terminate it, and then you'd be done and you won't get the rest of your equity out of this deal. That's never a good conversation to have. As a matter of fact, you're basically throwing the grenade on that relationship if you do that sort of thing. And it's kind of an a-hole move. I'll tell you, like, just make sure that if you are giving equity, that it's so nominal, so insignificant at the point in time that it's not going to be the major motivator for that person who's developing your mobile app or website. You want their motivation to be develop a great, beautiful looking mobile app or website and get paid cash for that, because money talks. People want to get paid now. They might be happy to take a half a point or a full point in your business, but I would just caution you against it. It's not the way to go about your relationships. And also think about it this way. Let's say you do become mega rich for some reason because of what you created is amazing and people really want to use it, and it just has ridiculously high growth as for an early stage startup. Well, that 1% or 2% or 5% that you gave away to your developer could have been worth millions. And so I would say be greedy when it comes to this and keep as much equity for yourself. Change orders, be careful with change orders, but do put a mechanism in there to amend the scope of work, to amend what you're getting out of this contract. Or if you're on the programming side or the developer side, just make sure you have a mechanism there for you to amend whatever it is that you're creating, right? Because at some point, somebody's going to say, that's not exactly what we had in mind, or, our vision isn't really coming to life here because I think we're not communicating well enough, which happens a lot, right? We definitely want you to, we definitely want the change order to provide for a smooth transition to an increase or decrease in scope of work, or a change in the direction, right? And we want to make sure that we're not executing change orders to redo work that was already done. We want to make sure that we're being clear as far as the initial scope of work, and then clear with any changes to that scope of work in the future. I've also put in actual scope creep terms, which I think is useful, right? So some contracts for development for mobile apps and websites don't include scope creep. I would actually put a buffer in there, at least, in a way you might be looking at it as, hey, we're making an estimate. It's almost turning the contract or the payment term into an estimate, but really you can word it so that it provides for, as far as the change orders go, you might not have to execute a change order per se, or you might execute a change order and then that's just rolled into whatever the increase that's provided for in the scope creep term and condition that's a part of the contract. So like we actually did that in a contract the other day, and I thought that was really wise because we provided for like a $5,000 to $10,000 buffer on the work, and I was like, that makes so much sense. That actually solves 2 or 3 separate problems. It doesn't require that I really get re-involved to amend a contract. It doesn't require that these people haggle again about what the price of the service is going to be. All they've got to do is make the choice to do that and then adjust it upward within the scope creep term. So, and then dispute resolution, I would recommend like having, as far as negotiating in the state of Texas goes, there's no duty to act in good faith as far as a negotiation goes. So if we put a negotiation term and say this person has to negotiate in good faith in the event of a dispute, it's not really that enforceable, if it's enforceable at all. A better term would be, before you go do arbitration or before you both sue each other, if the contract has extremely significant value, go ahead and go to mediation. So we can put a tiered dispute resolution term in there, where it's like, you have to do good faith negotiation, and you have to do like 2 meetings with them minimum, or 1 meeting with them minimum, and then it goes to mediation. Mediation would be less expensive than arbitration, but mediation is non-binding. It is a form of dispute resolution, and it might help save whatever project you've got going on, especially if you're scoping $250,000 or something like that, or something really high. You definitely want to make sure you're putting stuff like that in there, because otherwise you really are flying. You really are walking into a situation where potentially the only solution would be to sue somebody. And we don't want to sue people, to be honest with you. We want these contracts to end up being completed as written. Another important, probably the second most important thing to me as a lawyer, is ensuring that you own the intellectual property from from the work that is done by a developer. And, I think I've read certain development agreements, which I thought that's really not how we want that to be worded. And, it was written that way by the developer, or it's just an agreement that was bought off lawdepot.com or something like that. And, in my opinion, I was like, that's really not what we would want that to say, because that means that they own your app. Like, as they own the work product. Why would we just agree to have them license you the work product? That makes no sense. And so we usually try to get language in there that says the customer ends up owning the work product. And then usually there's background technology language like this in there that says the background technology, whatever the definition of that is, and we can change this if necessary to be more specific or less specific, but the background technology that is incorporated into the end product, the end work product, should be it comes with a license that is irrevocable, right? And we want to make sure it's not revocable, because if the person can revoke the license to the underlying background technology, you just lost every ability to run your mobile app. That's basically a poison pill term almost. Like you could just basically kill a company that way. And so I would never agree to that sort of thing. I do know that some developers would try to get a term like that, because they're just spiteful people, but for the most part, 99% of the people we deal with understand this and understand that this is a necessary part of the contract. It could be written in different ways, by the way, but in general, like I like to keep it a little more specific like this. Let's see, did I miss anything here? Yeah, perpetual irrevocable license and background check. Just make sure that's just the moral of the story there. Do we have any questions about that so far, or anything else I've talked about with respect to these agreements? Okay, awesome. So I will proceed. So as far as compliance terms, so these are pretty important, and I'll talk about why. With certain industries, you have to program the app a certain way. So let's say, for example, you're creating a mobile app that is going to be a telemedicine-based mobile application. So there's going to be HIPAA compliance concerns and that sort of thing. So basically, health information privacy concerns, and you're going to need to take in information and store information in a secure manner. So you definitely need to make sure that it is programmed according to that law. And sometimes if it is going to be that specific, we do go ahead and just put it in there into the contract, because why not? If we need it to be HIPAA compliant, we should definitely have something set that says you are going to create something that is HIPAA compliant for us. And in some cases, you may look at it and say, if the person who is creating a mobile app or a website for you, and they don't have HIPAA compliance programming experience, maybe you should find somebody who does, or maybe put it into this agreement so that, hey, this person has to go find an expert in that, and make sure that that person gives a thumbs up, or potentially even writes a letter or an email to both of you, the developer as well as the customer, saying this should be good to go based on my experience. In my opinion, the letter thing is usually never going to happen, but sometimes we do have people that attest to the fact that this is actually legit. It's done according to industry standard, that sort of thing, if the other people in the room don't exactly have the experience or technical knowledge and are just doing it at the direction of other people. Less common, but happens. Let's talk about this. So in the case of a fintech company, let's take Robinhood, for example. Robinhood has to be PCI compliant. It's basically bank level security. And there's 3 tiers to PCI compliance. And some of the people who are listening in on this will know more about it than I do, and will understand what that means. It's payment card industry standards, basically. That's what PCI means. And effectively, that means you're storing information in a certain way so that people's payment information, such as credit cards, bank accounts, ACH numbers, things that could easily be used to, defraud people of several thousand, if not hundreds of thousands of dollars in some cases. We want to make sure that if you need PCI compliance, that we put that term into the contract. It is more common because a lot of, some people who are building out their own software, who they want their own proprietary PCI compliant system, that definitely does need to be created, and that's a term that needs to go into the contract. Sometimes, though, we can just plug in some code, or you can, I guess, purchase the license to an API, and you'll end up, you can end up just purchasing a PCI compliant API that gets updated on a regular basis. That you just got to update it when the updates come out, right? We want to make sure it's the dev's responsibility to make the mobile app pass the review standards for App Store, Google Play, any other platform you need to be on. We actually had this come up in a conversation, of all things, with a fintech company that we represent. And for whatever reason, this massive company, we're talking a 60-page, 80-page contract, I think. Like, it didn't have these terms in there. And I brought it up to them in a conversation. I said, why is this just not clear in there? Because I was like, the whole point of this contract is that we're purchasing a mobile application, basically, clone from you and rebranding it and making it look more beautiful. We're purchasing all the back end that goes into it, and then dressing it up according to how we want. Why are we not? I was like, why are we not getting this compliance standard? And this person gave us the explanation that, hey, it's just this, like, it's covered under this term. And I was like, I don't care if you think it's covered under there. I was like, it doesn't say that. I was like, there's a definition in most of these agreements that says, like, it talks about the App Store, Google Play Store, and, it refers to compliance with this directly. And so I would just recommend, it's usually not a problem, but we had it be a problem one time when we were talking about, the service that we were buying from these people, by the way, the value of it was going to be hundreds of thousands of dollars a year. Like, as far as what the contract, or like what our client would have to pay to these people as a vendor. And I was like, that's just, if we got to get it clear when the stakes are that high, right? It was bizarre that we had to deal with that situation, but nevertheless, it happens sometimes. You never know what's going to come up when we're negotiating stuff. As far as documentation goes, I'll tell you, this is, we represented a client a few months back that did a very good job of doing what I call knowledge transfer, what they refer to as knowledge transfer. We entered into a software development agreement with a major company here in the United States, or like we helped them draft that and negotiate that agreement. And there were KT requirements, knowledge transfer requirements. It's basically documentation of what we did and when, or what the client did and when, and then what licenses, what code, what open source code went into the end product. And it doesn't have to be so granular, but we want to be able to call some of that stuff out by name or whatever the industry term is when you're putting together the documentation. And I actually saw the Excel spreadsheet that was used for this, and it looked very good. But I'll tell you, for high growth startups getting this type of stuff from developers, we don't see a ton of emphasis on documentation. I think that's more of an industry thing when it comes to developers. But I would, if I had my way, I would like to see a lot more documentation, or at least knowledge transfer, as far as, hey, here's the basic stuff that is going into this, the foundational elements of this program that we wrote for you, or this mobile app that we created for you. But I get that sometimes that may not really be feasible, because you're sitting there going, well, I just created something, I just coded it for you. It's not necessarily like something that we could refer to by name. I just made it. So it's not really a deal breaker, but I've seen some people be pretty blasé with the documentation. As a matter of fact, when I was starting I tried to start a software company about like 5 years ago, and I will tell you that was as far as documentation and knowledge transfer goes, the person I was dealing with was not the type of person who did a lot of that. And it was very frustrating. At one point, I just had to threaten to sue that person because they were not giving me my code. They're not giving me the work product that I had bought, basically. But anyways, like I said, if certain licenses go into it, maybe get a list of it, maybe ask for a list. I think regardless of whether a term is in the contract itself for this sort of thing, you can ask for this and the person will provide it to you, right? Because they'll know what went into it. And if it comes down to it and the person goes, we're not obligated to give you that, just pay them for it. Right? It would be useful for you to have if you ever had to give it to anybody else who has never seen the software or the program or the mobile app that was developed for you. And then, as far as make sure you get a file with the code, make sure you get a deliverable, make sure you get like, hey, we are done with this contract, or we are substantially complete. Here is your code. And timing of that also, does depend on, was it submitted for testing and debugging and all that other stuff? Did you go through that before you did all of that? And, but you do want to make sure that you at least get a copy of it at some point. I know that most developers have backup systems for everything, but you never know if that person is running your app and then something catastrophic happens, or or they're running their entire business on Google Drive or something like that, and they accidentally delete everything, you'll never get that stuff back. So I mean, it's a good call every now and then, probably, to just ask for progress, like a file that has the up to date progress as far as the code goes for the backend. That said, with a website, I don't think that's as big of an issue, because usually that's managed on third-party websites, and it's just you can go into a login system and find it. But I think with mobile apps, it's a little bit different. Examples of licenses language. So I'm giving you this as an example. So this is directly from a resource that we use every single day to create our contracts. And as far as the license goes, here's on the left-hand side here, we have, this irrevocable, perpetual, fully paid up, royalty-free license to the background technology. That's exactly the language we want to see. And then you want this other stuff usually. I mean, some of this stuff might be overkill. So arguably, if you include the section, like the language in section 10A1, potentially maybe you don't need this other language, but I would include it anyway, only because, if the argument goes both ways, this might cover everything generally, but you want the rights to use, you want the rights to reproduce, you want the rights to do with it what you want. These are basic property right concepts, right, that are incorporated into this agreement. So I see that they're missing in most developer written agreements, though. And so, but I just, as far as a development agreement goes, we want to make sure we're being clear. Okay. License to approve third-party materials. This could be a contentious subject for some developers, because they would look at this clause and say, you're hamstringing me. Look at this. You're telling me that for every third-party piece of code, for every line of code, even if it's just two lines of code, I've got to get your consent for it. In some cases, yeah, and this might tie into reimbursable expenses too, because if you are paying a third party for for a line of code or a couple lines of code or an entire bank of it, or if you're paying a third party for that API that you're just going to incorporate into your website or mobile app, then you might want to have this in there, because you don't want them going, I'm going to buy the Rolls Royce that'll cost you like $10,000 a month total in all licenses. You probably do want to screen that a little bit and make sure that, hey, I'm understanding the increase in ongoing license fees for this business, right? Because in my opinion, it would definitely be wrong of you to not at least have a term that says that they have to provide you notice that they're doing it at minimum. If you do want to have everything run by you, then I would say include this language, but maybe the approval needs to be directed to your chief technical officer if you have one, so that the person is dealing with somebody who knows whether you need that code or not. Aside from that, will you need maintenance and support after initial development? This is something that we don't include, every single time. It's something that we definitely have to ask our clients about. And the question goes, hey, when all is said and done, when you've got your mobile app, and you're in beta testing, or you've actually launched the app on the App Store or the Google Play Store, are you going to need ongoing support, or are you going to go in-house on that and have somebody who's a developer just working for you? That's a question that needs to be answered before we sit down and draft these things, or before we negotiate it, because it factors into the overall amount of fees that we have to pay to the developer. And, it would be convenient really to make sure that this is rolled in, or at least tacked on in the initial contract, to say, hey, for a period of 6 months after development or after the deliverable has been delivered to customer, that you're going to go and do ongoing maintenance and support. And so this is especially what we want to see if we're doing hey, the next 6 months are going to be debugging, beta testing, enhancing some of the features on a limited basis, as well as just, support for scale, right? So you want to have somebody who can help you. If you have a massive influx of users, probably need to have that support on hand so that you can adjust for, hey, traffic to the app, traffic to the website, things like that, so that the thing isn't crashing on you all the time and you don't have anybody on the back end supporting you for that. But yeah, I say here, ask for a flat rate or reduction in hourly fee for this. What I mean by that is just ask for it. If they say no to you, they say no to you. But sometimes people say yes, and you'll be pleasantly surprised how much you get if you just ask. I've asked for completely unreasonable things before in contracts, and people have given them to me. To me, it's just like, it's mind-boggling what somebody will actually give you, so long as you're willing to have the guts to actually ask them for it. So I say, you miss 100% of the shots. You don't take. You should definitely ask for it. But in the event they just tell you, hey, ongoing support and maintenance is going to be at our typical hourly, it's fine. It's reasonable. It's a skill-based, knowledge-based work. So, we got to pay people what they're worth for it sometimes, right? Should you agree to reimbursable expenses? Typically, yeah. Within reason. Most developers aren't going to be charging travel expenses. So you'll see in this little snippet that I'm giving you out of from our mobile app development contract, it shows, travel and lodging out-of-pocket expenses. I'm definitely not giving you travel and lodging unless we need to fly you to like San Francisco for something. That would be ridiculous. And even like, if you look at this clause, if we took that travel and lodging language out, fine. It still applies anyway, because if you look at it from time to time for direct documented out-of-pocket expenses, if you're doing travel for the purpose of developing this mobile app or website, it's covered under that anyway without us even directly mentioning it. So I usually err on the side of taking the travel and lodging language out because it's unnecessary to begin with. But in the event it is necessary, cutting it does not really change the enforceability of this clause with respect to travel and lodging. And then, as far as the reimbursable expenses go, it's like I said, license fees for other code that might be from third parties, or for integrations and things like that. Other reasonable expenses as far as the utility of an app or website goes that they need to pay for, enhancements in the product or service that you're creating itself, all rolled into that. Sometimes though, we do propose no reimbursement of expenses. I would say most people will kick that back and say, no, we have to be reimbursed, because it's not just what's going into that hourly. We usually do, like, they have to get covered for their expenses because they got service providers to pay for. They might be charging you $100 an hour, but they're paying some dude $55 an hour probably, or something like that, to code it for you, who's a contractor for the company or something like that. So, or they might be paying even less. I've heard some people get paid less, and I was like, you should probably get paid more. Aside from that, yeah, it talks about the third-party materials, and sometimes we just set a number on it. So if you see subpart D right there, it says any individual expense item in excess of blank shall require prior written approval. Whatever you think is reasonable there, I could make that $50. I could make it $5. If you spend like $5 of my money in the grand scheme of things for $100,000 contract, I don't care. Like, well, you probably needed it if it was $5, but just don't be going. Don't be going and spending money on food and drinks if it's not a direct business expense, right? By the way, if you do include this reimbursable expense thing, definitely make sure that it includes receipt language. You want to make sure you get the receipts, because those are business expenses. Probably want to give them to your accountant. Now you need to get out of it. So we do have a question. I appreciate this, by the way. Uh, what if you wrote a crappy developer deal and now you need to get out of it? What are your options for exit without making a bad deal worse? So first place to look is going to be, look at the termination provision. Does it allow you to terminate with notice within a certain period of time? Does it allow you to exit the agreement, right? I would say look to that first. We definitely need to make sure we read the terms of the contract and understand them and are interpreting them correctly. So if there isn't, termination provided for that, at that point, then maybe what you want to do is potentially contact the person and tell them that you're unhappy and tell them that, when I first got into this, I wasn't really sure about it. Right. Or maybe don't say it that way, but just say, I was a bit naive and I didn't realize what was going into this agreement and what terms I would be subject to. Is it possible we could discuss amending the agreement? And, if the person on the other side of you is going to treat you like a human being and say, hey, we get it. These things happen sometimes. Apologies that you're not happy. Yeah, let's discuss what you want to do about it, right? I think that's a very soft approach and, a good approach as well, because, some people will never know that you're unhappy unless you tell them. And, in some cases, that is the best thing. That is the best medicine for the situation. We don't need to sit it's not necessary in some cases that the lawyers get involved. I'll tell you. I've had certain things happen where, the lawyers didn't get involved. And actually the client themselves just took my advice, went against it, and ended up discussing things directly with the other party. And at that point, they ended up saying, oh, well, hey, we just want to come to a new agreement. We just want to make sure that we adjust this because I'm just not sure this is a good deal for me anymore. I'm basically paying, I'm getting absolutely hosed here. People understand, normal people. And I would say be cautious about getting a lawyer involved directly at that moment, because the problem with lawyers getting involved is people tend to dig their heels in, and regardless of what the situation is, people, they tend to say, no, F you, we're going to take this and, we're going to keep holding you to this agreement. And so but if that's the type of thing that, is a reality for you right now, I would recommend, giving somebody like me or another lawyer who does this sort of thing a call and just talking it through with them, because you might be able to, we can give you some insight into how to deal with the particular situation, as well as it's important that you probably have a professional read that agreement so that we know exactly where the weaknesses are and what is to be negotiated, right? Because what you definitely don't want to do is tell somebody that you're not happy with an agreement and it's really just a matter of, hey, I'm just not reading this correctly, or we're actually not implementing it correctly in some cases. That does happen where parties agree to one agreement, they're doing something different in reality. And so you just got to, it's a matter of refocusing the parties at hand and telling them, this is the agreement, we need to stick to this. And as a matter of fact, if they continue, if we do that and that person ends up saying, we are not going to do that, then we might actually have some sort of legal situation where one party is breaching because they're basically telling you they're not going to adhere to the term of the agreement. But yeah, so as far as that goes, that is a phenomenal question, by the way. As far as making a bad deal worse, there are certain situations that we discuss with clients where, if there are no other options, then in some cases, not the best option, but the most likely option is to intentionally breach. We don't recommend it very often for a very specific reason, because we are in the interest of avoiding going to court and avoiding increasing expenses for for the parties involved, right? And also, if it's something that you do want a continuous relationship with, that has to be taken into account. We're trying to preserve a relationship, preserve a business relationship with these two people. But I will tell you, if nothing, absolutely nothing can be done, and you are both totally at odds, in some cases, just breaching is the most effective way. We have dealt with certain situations, by the way, where we have coached the client and said, it's more efficient for you. You will make more money in the long term, or at least in the next year, if you just stop doing this and let them settle with you, and like to just cancel the agreement or terminate the agreement. And that's another option too, by the way. If you don't want to work with that person anymore and there isn't a termination clause for that sort of thing, it may make sense for you to propose a termination agreement, and you could pay a certain set fee to terminate an agreement. We actually have a termination agreement template that we use for those exact situations, and I've used it actually more than I would have liked it in the last few months. But then again, some of the agreements that we get are not lawyer drafted, and they do need to be terminated in that fashion. And also, it's just I'll tell you, like, that is a good way actually for two people to come to a meeting of the minds and agree that, hey, we are no longer going to do this. It's best if we both part ways. Here's how we're doing it. And if that's something of interest to you, I would potentially consider it. So termination, I just talked about this. So try to avoid agreeing to break fees that are percentages of the total project or entire remainder of the project. Just so you're aware, from a contract standpoint in the state of Texas, you technically cannot agree to a fee that is described as a penalty within the agreement itself. That, as a matter of fact, is pretty much void. There are certain ways around it, by the way. Like, for example, I could instead of calling something a penalty, like I could call it a late fee, or I could call it a break fee, or a termination fee, or something like that. And that's what I'm referring to here. But I'll tell you, yes, some developers do. They staff people. They spend money to make money. And so part of the break fee, in some cases, if it's a percentage of the total project or percentage of the milestone at hand that you are doing right now, it's probably, some developers will say, we got to have that, just to cover costs. It's our opportunity cost for being available to you for hundreds of hours of work, right? That might be reasonable. You're getting the benefit of the bargain there. You're getting their time and availability, right? Aside from that, though, as far as smaller developers go, some smaller developers don't need a break fee because they're doing it all themselves, right? It's just one guy with a company, or one guy who's just doing it under his own name, right? And then on top of that, I would say don't agree to anything where the termination clause says the developer can withhold the work product. Usually the exception to that is if you are not paid up in accordance with the remainder of the contract. In that case, I think it is actually acceptable that they withhold, because technically if you haven't paid for their services, they do not owe you the code, in my opinion. Like, you do have to give them the money they are owed to get what you purchased, right? But aside from that, also, good rule of thumb here, make sure the termination clause requires no more than 30 calendar days notice. Any more than that, and it can be a bit inflexible and cost you a lot more money in the short term. Also, if you're ever looking at an agreement for something, with larger scale contracts, with contracts that will require a lot of individuals to help out with its completion of the project or each milestone, maybe a longer, notice provision is appropriate, like a 60-day notice provision, because in that case they have to readjust their team and go out there and find new projects to do. And so you're locking down a whole lot more people in those situations. But If it's a smaller group, then I think 30 calendar days notice is fine. I would actually insist pretty much on allowing for, immediate notice upon, so long as it's provided in writing, because what that allows you to do is allows you to like turn the faucet off, so to speak, and eliminate that expense, or at least, mitigate the expense and mitigate the damage being caused if you have a reason to actually do that. But it happens pretty often that a customer gets unhappy with a developer. It happens a lot, actually, to the point where it is something that we have to deal with on a regular basis when we talk to our when we're working with our clients. They'll sit there and say, "I'm just not happy with these people. What can I do?" And then we look at the contract. Aside from that, one last thing: public announcements. Sometimes these people will want to put you and feature you as a client on their website. Make sure that's something you actually want. Some people are in stealth mode, by the way. If you're in stealth mode, don't agree to a public announcement. Don't agree to let somebody use the logo of your company or description of it or anything like that. I mean, you need part of what you need out of every agreement with every service provider, if you're in stealth mode, is confidentiality. And you need it to be fairly strict, and you need to enforce that too. So just make sure that if that is a need for you, do that. Aside from that, though, I've had certain clients, they don't care. Yeah, go ahead, man. But at the same time, some people don't. I have one particular client who is insistent, and actually he's offended some people with this. It told them straight up, I don't want you using my trademarks or my logo. And part of it's just what he means when he says that sort of thing is he's just adamantly protective of his brand, and he does not want anyone else sullying his brand. I mean, his mentality is, if I'm the one who's going to cause damage, if anyone's going to cause damage to this brand and or have it have negative press, it is going to be me and no one else. And so in his software development agreements, we actually ensure that it's known that, hey, you do not have the right to any public announcements. You do not have the right to feature the logos, trademarks, or descriptions of what the company does. And you have to ask for permission if you do want it. And as a matter of fact, we get to deny it. We get to deny it in our sole and absolute discretion if that's what we choose to do. I would say more often than not, though, public announcements are included, and we give those rights fairly freely. But you do need to consider them, because to be honest with you, I wouldn't. In some cases, I have actually had some people use our information on their website and tell the general public that I was their lawyer, or our law firm was their lawyer. I basically, that was a bit strange to me. And so I probably wouldn't allow people to do that anymore. Also, we don't want, for companies like ours and certain other companies, there are rules related to what you can and cannot say about a company like ours. And so that was sort of blurring the line a little bit with respect to the rules for law firms. But I mean, the person pretty much did it without my permission. Aside from that, the other terms here, reps and warranties, you're basically just getting promises and assurance there that, hey, the end product, the work product, is going to be as requested. It's not going to contain any harmful code. It's not going to contain, a poison pill or a time bomb or anything, or anything that could disrupt its operation intentionally, right? And then, survival of certain terms. We want to ensure that, your obligation to pay survives. Because you do need to pay under these contracts. We want to make sure that the obligation of confidentiality survives for a certain period of time if necessary. We want to make sure that some other obligations, such as indemnification and limitation of liability, survive as well, because we don't want anything that you might have done, that a programmer might have done wrong, to harm the company in the future. But we do want to put reasonable limits on some of that stuff. It's not going to survive for 10 years. It's going to be it'll survive for 6 months, a year, maybe 2 years at the most afterward. So it depends on the value of the agreement. Aside from that, submission for review and testing. Submission for review and testing, So if you need to beta test this thing, if you want to be the person who helps debug it, if you want to do all of that stuff, then make sure you get a term like that. We don't want, we certainly want to provide you with the opportunity to do that, because I mean, nobody wants to receive code that doesn't work, right? Nobody wants to receive a program or a mobile app or a website that is so bugged up you can't use it, it's crashing all the time. So, and that sort of plays into the reps and warranties too. I mean, if you're delivering code and it hasn't been tested, then you might not have done your job under the agreement, because you warranted that you would test it and debug it to a certain extent to ensure that to ensure that the work product you got was what you wanted. And also, this one of the other terms that plays into this, acceptance after submission for review and testing. We do want to put a certain period of time on that just to move things along. So you've got maybe 14 days or 30 days to provide testing notes on it, and just improvement notes or something like that. And that might play into any number of change orders or scope that we recreate for you. And then the other thing, I just threw this in there, open source. Sometimes, I do have to ask the question, is any open source stuff going to be included in this software that's being developed, or this mobile app or this website? If so, we throw the open source language in there. We give the developer the right to use open source stuff, and then it would be subject to third-party approval, right? So aside from that, so you have aside from that, that's about all we have for today. I'll tell you, we're a bit over time by about 10 minutes. It doesn't look like we have much in the way of other questions, unless somebody wants to ask a question right now. I'll stay on for about the next minute or so, see if one of those comes in. But other than that, if that's about it for today. I appreciate everybody who attended coming in. I definitely appreciate the activity in the comments here, as very engaging. I hope we get to do that a lot more, because the commentary was definitely very beneficial for me, I'll tell you. As far as this goes, though, again, my email address is kyle@joneskertz.com, JonesKertz.com. If you have any questions, feel free to go ahead and email me, and we'll be in touch. All right, well, it looks like it's been almost a minute. If no one has any other questions, I will say goodbye, and I'll see everybody next month on the first Tuesday of the month. Take care, guys.